we'll wait for a few more people to sign on. We got a lot of work to do. Good work, and we're close. So the sponsor for this bill will be Gail Harrell in the Senate, and we're looking at a House sponsor. You know, Caruso has resigned or will be resigning, Mike. And so we'd like to get someone in the House that is familiar with the space. I know that Representative, I believe Weinberger is someone that Dale Harrell would be speaking to. And Davenport has been mentioned as well. So if anybody, you can put it on chat or you can bring it up, you know, if you have anybody that you suggest we contact and send the legislation to. And Terry, you wanted to mention something before we started the meeting?
Yeah, appreciate it very much. A lot of you have seen that Dave Ehrenberg has a book that he wrote called
He,
Fighting the Florida Shuffle.
he does.
Yeah,
Really?
have you seen that?
Who knew?
It's and there's also a movie that many of you don't know about, documentary that was made called Shuffle. And Shuffle's producer and I have gotten together and with Dave and created an event on October 6th in Coral Gables at Books and Books at 5:30. Dave will be speaking about his book and presenting his book. And then we're going to go across the street to the movie house in Coral Gables and have a screening of the movie Shuffle with a Q&A afterwards. I'm going to put it on my LinkedIn, Facebook, anything and everything I can to get it out there. And I can put it in here in the chat, I guess I should be able to. I'll try doing that. If I can't do it from my phone, once I get back to a desk, I'll send it from my iPad.
Can you tell us the date of that again?
October 6th
And it's in Coral Gables.
in Coral Gables at Books and Books,
And what time?
5:30
Tell you what,
is the at Books and Books, and then, excuse me, I'm sorry, 5 o'clock, not 5:30. October 6th at 5 p.m. And the movie is October 6th, the same day, at 6:30, right across the street at the Coral Gables Art Cinema.
Okay.
hey, for ease of everybody, Terry, just send that flyer to
Marianne,
Marianne, and she'll send it out to everybody.
right. Beautiful. Thank you.
Okay.
Thanks, Marianne.
Yeah,
Thanks,
Al,
Al.
I just don't want to, for whatever it's worth, I don't know who's actually read the book. I read the book. I don't
Jeff,
know.
Jeff, can I maybe get to what you were
Yeah, get
about
to
to
it.
say?
I just want to say that I want the task force to focus what we're focusing on. And if we're going to start getting into conversations about Florida Shuffle stuff that's 10 years old and stale, I'd rather we not. Otherwise, I'm going to openly criticize the book for its foul. And I've talked to Dave about how it makes it seem like 2025 is horrible and that we've done nothing, and that this task force really isn't given much shrift. It's all about Ted Paddock arresting people and Kenny Chapman. And I'm being the only person here who represents private industry. I'm just speaking up that I wish we'd stop doing that. It makes what we're about to do harder, which is zoning, because we're going around in books and celebrating that what happens in the world and doesn't happen in Palm Beach County anymore because of this group. So I just want to put out there that I love Dave and I've been friends with him for a long time. We grew up in the same neighborhood. But I do not agree where we are today. We are in a phenomenal place because of this group. This legislative group has done phenomenal work together. And this group is the poster child of how to fix things. The book goes on and basically says how private addiction treatment has ruined the world and that the Fair Housing Act, the ADA, and the Affordable Care Act needs to be changed. I don't support any of that. And I don't think people have read the book. So before people start lauding the book and saying how great it is, I think we just need to not have that conversation in this group is what I would ask for. Because otherwise I'm going to have to speak up. I'm not going to be quiet and allow the continued, and I'll leave with this, where it's not where a few bad apples spoil the bunch, it's where the entire bunch is spoiled, which was said on Megyn Kelly on MSNBC in 2016. I that hurt back then and it hurts today. And so I'd let Dave know that. And he understands. But you know, if it's salacious and it bleeds, it leads, it does. So we'll leave it at that. I'm just gonna ask we don't talk about that subject here, else I'm gonna have to say something back.
Well, other than the fact that there's an event in Coral Gables,
Right. We're not talking
Uh,
about it.
we're not talking about it, but I will put a postscript on what you said, Jeff, because I was going to bring this up. It's a historical piece. I think it's accurate in many ways. None the least of which is the fact that the legitimate industry, the ones that were getting killed by patient brokering, were the ones that brought action and created this group. They're the ones that went to the legislature because without their support, the good actors, we never would have gotten a foothold. And it was almost like a leech. They had to bleed in order to get this resolved. At the end of the book, Dave does say, Dave and Dr. Campbell both say that things have been cleaned up in Palm Beach County and the state of Florida, which they have in many ways, large ways. But it's still going on around the country, and that is true as well.
Mhm.
Brokering is alive. The bad actors are in Orange County, California. They're in Austin, Texas. They're in Asheville,
Broward County.
you know, and so from a historical perspective, and really, we're not here to discuss the book. I've read it. You know, I was embarrassed by being mentioned in it, you know, in a way, because it's not why we're here and it's not why we do what we do. But it is historically, from a historical perspective, and this, when it was called the Sober Homes Task Force, this group, as Jeff aptly puts it, was very influential in getting this problem in South Florida under control. So Jeff, I agree with you. We're not discussing the book here. It's not appropriate until we start discussing history, and we're not. So to that end, Jeff, I'm glad you had your say. And you know, like I said, I agree with you from a perspective of it should have been a little more prominent that we've come such a long way here in Palm Beach County. And Dave knows it. I've told him that, you've told him that, and others
Yeah.
have, I'm sure.
Mhm.
So, yeah, so about the subject we will not talk about, let us move on. And we got some stuff to do here. I'm going to call a roll, but I have we have put together a working group that is largely going to be speaking to the words that are in the legislation to see whether we can make a better mousetrap to send to the legislature. But everybody is invited to talk. And so I'm going to go down, see who's here. Belma, are you here? Belma Andriek, is anybody here from the healthcare district? No. I think they're all at the county commission meeting. Okay. Tom Baird, attorney, land use attorney. I got to talk to Tom, see why he hasn't been around. Turner Benoit, Turner, Hanley Foundation. Turner's usually here. Could you reach out to him and see what, okay. This is,
They just sent him a text, Al.
this is a special meeting about legislation, so he probably didn't want to watch paint dry. So, Ann Berner, SFBEN, South Florida Behavioral Health Network. Ann, anybody here from SFBEN? Ariana Ciancio, Delray Beach Police Department.
I'm here.
Hey, Ariana. I do think that our attendance will be light today because we are discussing legislation and it's not in the wheelhouse of some of our members. Dr. Anita Kukovis, Hub, Community Recovery Hub. Okay, Uta Gaziak, Florida Behavioral Health Association. Shoot an email to a text to Uta, please. Thank you. I saw Dr. Green, Dr. James Green, you're with us. He's here. Jim?
He's here. I think he's still on now.
Okay, maybe the mute button is giving him
Yes.
problems.
He's here.
Okay, I was gonna ask, Dr. Marino, I was gonna ask you how you got out of the, county commission meeting, but okay, glad to see you here. Tama Kudman, attorney. Please reach out to her as well. We're gonna
Okay.
take her off the list.
Okay.
Anybody from DCF? Kelly Lee is usually here. DCF, you here?
Yes. Somebody's here.
Who is here from the department?
Angela.
Hi, Angela. Okay, multitasking. I see Jeff Lynn has already announced his presence with authority. Welcome, Jeff. Nancy McConnell, CEO Rebel Recovery. Nancy? Neil McGarry, Florida Certification Board Executive Director. Neil? Okay, not in his wheelhouse today. So Michael McKeough from Oxford House. Michael, are you with us? Anybody from Oxford House? Okay, Dr. Moran. Dr. Robert Moran, Family Center.
No.
Need to reach out to Dr. too. Dr. Rachel Needle, saw you were here. Hi, Rachel. Houston Park, Florida Department of Health. Houston, are you with us?
Yes, I'm with you.
Oh, hey, Houston. Another person who was there at the beginning. Thank you. Terrell
Thank you.
Pyburn, Coconut Creek City Attorney. Terrell? Terrell, are you signed on?
She should, I just was on a call with her. She should be, unless she's running late.
Okay,
Yeah, I don't see her here, but we just got off the phone before the meeting started.
okay. All right. I'm sure she'll be tuning in. Susan Ramsey, I saw you're here. Susan Ramsey, legal counsel for FAR. Susan, this is your last meeting as a member.
What?
Understood.
Okay, we don't need two people from FAR. We've got Michael Schlossman, who, by the way, is next up. Michael, are you with us?
Thanks.
I wanted to see that I'm present.
So I'm Susan's emotional support human. Is that okay?
Okay, woof woof.
Oh, behavior qualified residential treatment program. We have to.
Okay, Terry Shapiro. GIS,
Present.
Economy and
Thank
Finance.
you.
Of course you're here on your car phone. Don't get in an accident, man.
Not
You're not covered on your insurance policy, which does not exist. Okay, Nikki Soda. Nikki, are you with us? That's another text. I'll handle that one. Dr. John Simonides from FSAM. Dr. John? Yes, there.
Yes, I'm here. I'm here.
Thank you. Alton Taylor from Drug Abuse Foundation. Was that you, Alton? Okay. Jan Toman, South Florida Opioid Alliance. Jan? Okay, Dr. Lori Vinicor, Alliance of Del Rey.
Here.
Thank you. Your perspective is wanted and needed. Okay, Greg Weiss. Yeah, of course, he's at the commission meeting, so I doubt that there's anybody from his office. Niels, are you here? Okay. Richard Worms is no longer. He's been transferred to a different part of the AG's office. There is a new AG, assistant AG. Are you on? I don't have your name here. I will flesh that out for next time. Okay. And Eric Urlano. Eric, you with us?
Yeah.
Okay. All right. We are here to do some woodshedding on 419 rewrite. We've been talking about this. We had a version of this last year. This is cleaned up quite a bit from last year. And it actually has input from the legal staff, the staff writers over there in the Senate. So I know that Dan Lauber is on, and he's basically the architect or the writer of this. Dan did the study in 2023 and 24. And so we're going to just get right into the weeds and start with, you all should have the lined version of 419. And we'll start with 419.001, which is the definitional portion. And we're going to go paragraph by paragraph. If anybody has any input, any suggested changes, or any comments. Okay, most specifically from the working group.
Hey, Al, before you begin, I don't know if it's me. It probably is me. Is there a way you can make that larger as a document, or is it something, a setting I need to change on mine? If anyone knows.
I think we can make it a little bit, well, can we? Yeah, there we go.
Okay, thanks. Yeah, there we go.
All right. Okay, is Terrell on yet?
Yes, I'm here.
Oh, hi, Terrell.
Good
Welcome.
afternoon.
All right, now we're complete. So let's go through lines 14 through 47, which is the first definition, community residence. Any comments? Again, we've gone over this. This is, I believe, unchanged from last year. Anybody have any comments on lines 16 through 47? Okay, hearing none, let's move on to the second page. Congregate living, the definition 59 to 79. Any comments on those lines, 59 to 79?
Al, it's Jeff. The only let me see if this is the one congregate. Yeah, I just, as long as everyone's aware that, and I'm fine with it, that this definition includes inpatient treatment centers, DCF and ACA licensed inpatient treatment centers.
I think it's meant to. Dan?
Yes, I just want to make, yeah, for people that haven't delved into the weeds, I just want to make sure everyone knows that that the paradigm that's being created takes the idea of a CLF and takes all kinds of residential plus clinical plus medical types of uses and puts them all under this definition.
Right.
I just want
And-
everyone to be aware, and including non-detox but inpatient treatment.
Okay, and of course, at 79 to 77 to 79, a congregate living facility is not a community residence or recovery community. I think it's supposed to be that way, but thank you, Jeff.
No, it is. Yeah, I'm just making sure people know that so they can.
Okay. Now let's take disability, the definition, 80, line 80 through 91. Actually, we're going to go through to 101.
Hey,
Any
Al,
comments on that?
I do need to take a closer look with Susan offline about some of the stuff dealing with 397.47 levels 1 and 2 versus 3 and 4. So I'll get you those comments separate.
Those have been pulled out, I think, Michael.
Yeah, the levels.
Oh,
are
they were?
in the
The
legislation.
levels have been pulled out. Yeah, we talked about it. We just didn't want to start confusing cities or anybody else because
That's what it
reasons,
was. I was confused. Yeah.
Yeah, plus because we understand as far as re-examining how to deal with level 3s, possibly. Right. Okay.
Got it. Okay. Thank you.
All right, great. Okay, so we'll move on then to line subsection 4, lines 102 to 108. Family community residence. Any comments on those lines? Actually, let's go down and conclude 4. So we'll go from lines 1.
Oh, and Al, also, it's Jeff, just for people who don't know, these definitions overwhelmingly track with the work that Dan Lauber's done in his codes and studies since 2016 in the cities. So he's tweaked them to make them as current as possible. But for anyone who has experience with those codes, you're going to see a lot of similarity in here.
Great. And that's what we want to do. We want to have some consistency. So thank you. So going again to a family community residence from 102 down to 136. And I do have a question, but I want to hear if anybody else has any questions or suggestions. Okay, lines 131 to 136. There's a limitation. Okay, never mind. I think I know why. A recovery residence, where residency is typically more than 6 months.
Mm-hmm.
I just want to make sure I understand why it's limited to just those recovery residences. But I think it's because when we're not including the levels, we don't have them in here, but the level 3 and 4
Right.
intensive treatment where it's shorter residences. Okay.
Well, and also because Al, it's a
Excuse
possibility
me.
that 3 or 4 can be longer or not. That's why we talked about it.
Okay. All right. Yes. And so who said, excuse me?
It was me. I'm just asking about that because it's a little confusing to me because a level 2 or level 1, I know they're not in here, but as I look at them, it has at least 6 months, but not all level 2s are 6 months, right?
But it's the typical stay. It has to be. So there's some flexibility in there.
Okay.
Yeah.
I mean, go ahead.
I was
That
just saying
was
for
my
zoning
concern.
purposes, is what, I'm not speaking for Dan, but we have to create some kind of performance standard. How does it perform for it to be, and this is what Del Rey had done years ago. How does the use perform to be compatible and consistent with the surrounding neighborhood? And so to be consistent and compatible with a single family zoning scheme where there's longer stay, the same way we all object to, Airbnbs being in single family neighborhoods. The family community residents had the indicia of a longer stay, which, while we all know is typically could be a 1 or 2, we also know that's not true. A 2 could be less. So that's why we said typically. So the cities at least had some kind of performance standard to identify during the application whether an applicant is more likely to be approved as a family community residence or a transitional community residence. Does that make sense?
I mean, my only concern is, in the event a recovery residence, typically level 2, and the folks are staying 4 months, are they then going to have trouble with, I mean, that's my concern.
Yes. No, they are going to have trouble. And then what
That's-
happens is that Dan created the mechanism to go before the boards for the public
Okay.
hearing to apply and say, hey, even though we're 4 months, we're really not inconsistent with the neighborhood, and here's why. Now, I don't know if a city's going to care about that, but at least there's a mechanism for them to at least endeavor to, there's public hearings and you need an application. It's a whole process. It is, but there is a mechanism,
So if I could, I think, Jeffrey, you're getting a little bit ahead because while that is correct, there is a separate definition for transitional community residents, which provides for those residences that have a shorter term stay are permitted as of right in areas where transitional community residences are allowed, whereas those residences that have a longer term stay are permitted as of right in those areas where the family community residence is allowed. And then there is that exception that you can apply for to explain, hey, look, we're a unique situation here. And there is kind of that out clause or that escape valve, if you will, but that's a little further down the road. This is just the definitions. I did just want to point out, though, that I do know some cities where Dan had assisted them with drafting their ordinances do have under their definition of family community residence, they reference stays of more than 1 year. I believe at some point that was modified. Maybe it was with Coral Springs or one of the other cities. And I just wanted to point that out. So that may be a little different than what a few of the cities out there already have, but I don't think it's a significant difference. I'm just mentioning it so you're aware.
Yeah.
If I may, on line 133, change more than to at least. So we keep the language consistent.
Right.
Oh, okay.
And to amplify what Terrell brought up, the transitional community residences.
About your job? Yes.
Wait,
Did you tell Caitlin?
someone's on their
Please
phone
mute
talking.
yourself if you're not
When?
speaking.
I just remembered.
Yeah, I think you got it. All right. Okay, now, okay, that sounds right. Again, my reading of the study and all the different states and everything that's been going on is that 6 months is pretty much standard for family recovery, family residences. And so, we're pretty much, as Jeff said earlier, using the standard language that's used across the country. So everybody's speaking the same language. I'm okay with at least. Anybody have a problem with instead of more than at least 6 months? Again, it's going to be a standard where, how do you pin that down? It's,
It's very difficult.
yeah, so
Yeah.
so I think we got to come up with something, and coming up with a standard that's the national standard is probably the way to go. So unless anybody has a problem with that, let's go on to 137 to 142, which is number 5, licensing entity. Does anybody feel that somebody's left off as a licensing entity here, or something should be added or subtracted? Okay, what I would suggest on the Florida Association of Recovery Residences or other certifying entity as determined by the Department of Children and Families. Anybody have a problem with that? Because while FAR, we realize, we believe is going to be the 1,000-year, certifying entity, you just never know, since we're writing it into a statute, what FAR's is designated by the department, so we should put that in there.
Yeah, technically,
great-
to your
great
point, it's not
point.
a licensed entity. Yeah, they don't license, they certify. And that was when we crafted this legislation 10 years ago, we were really important under FHA law. We were really cognizant of that they don't give a license. And even though it's just semantics, there's law out there that says you can't give someone a license for housing, right? So we were just careful.
Should we say licensing or certification entity?
Yes.
Certifying entity?
Certifying or licensing entity is determined by the Department of Children and Family Services. And I will disagree with Jeffrey that even DOJ and HUD, when they actually enforced the Fair Housing Act, agreed that sober homes, as well as all other community residences, can be licensed.
Okay. Well, when we spoke to them 10 years ago, they were saying certified, so maybe they changed their mind.
Well, but
things change over 10 years, right?
Okay. Well, I mean, words have meaning. So should we include licensing or certifying entity in line 137? Or should we leave it alone? But I do believe that we need to put the Florida Association of Recovery Residences or other certifying entity as determined.
I mean, because there's a possibility that legislative drafting is going to strike far from the language, but so that's why you need to have a certifying entity.
Well, we'll figure that out. I mean, if they want to strike far because it's not licensing entity, then we need to.
No, I meant like there's actually a name. I'm saying it's not a
Yeah.
state agency. They may just strike it just because it's not just Sherman Act kind of stuff. It's fine.
Or determined by the Department
There was
of Children and Families.
There was a comment in the chat about Department of Health not being mentioned. I'm just not familiar with what the Department of Health licenses as far as residences. I don't know if somebody else has an idea.
Well, Department of Health, do they license?
I don't
No,
think
ACA, no, because ACA is the way it works is that when we split off from HRS and created DCF and Department of Health, they then created ACA as the facility regulatory body in partnership with Department of Health. But Department of Health licenses professionals and creates regulations for clinicians and medical professionals, and ACA is the facility approver. So it would be ACA that would be approving. I mean, unless I'm wrong, I don't think Department of Health approves structures, facilities, rehabilitation centers, homes. It's ACA that approves them.
That's my understanding as well. I just wanted to make sure I wasn't missing
Yeah,
anything.
no, we can put it in there. It doesn't hurt. I'm just saying, I don't think if we don't have it in there, I don't think we're hurting anybody.
Okay.
We can always add it. Yeah.
All right. Local government it appears fine to me. I don't know if anybody has any issues with that. Okay. Let's move on to number 7, lines 165 to 173 on page 5. reasonable accommodation. Anyone have any suggestions or additions on the language? Okay. By the way, if anybody does have something to say, please raise your hand. Can you see hands when they come up? Because I can't hear. Okay. So raise your hand, which Dan did. And so please, everybody do that. I want to welcome Sam Wagoner. Hi, Sam. Thanks for joining us. We're at line 174 now. Recovery community, the definition from lines 174 to 192.
Different.
Okay, any comments about that? Additions, subtractions?
Yeah, the only thing is in line 184, I'm just noticing now we got to do a global, the word agency is there. We probably have to go back to entity. No? A single sponsoring agency or group of related sponsoring agencies.
Oh, yeah.
We want you
Entity.
Under the auspices.
Yeah, just make a note, do a global look for agency and possibly replace it with entity. That's all.
Under the auspices of a single sponsoring entity or group?
Yeah, only because agency overwhelmingly means a government agency.
Well, that's why we added the word group, I think. Dan, you
You
want
know, it's perfectly fine. It's perfectly fine to change it to entity.
Okay, so we'll change agency to entity. All right. Entity or group of related sponsoring agencies.
Can I go back, Al? Hi, I wanted to ask about reasonable accommodations, and obviously I'm not an attorney. Can you go back up?
Yeah, we're going to have, there's a lot of reasonable accommodation language
Yeah.
that specifies what it is and how you apply it. But let's go back then to reasonable accommodation, which is, I believe, on page 3. No, it's on page.
It's up right now.
Oh,
Line
up on the top there.
165.
Okay.
Yeah.
Yeah, 165 to 173. Go ahead. What's your concern, Courtney?
So it's really vague. I mean, obviously I'm not an attorney, but what would be, I guess, the disability would be by the Disabilities Act. I mean, and also there's legal risk to the house manager for taking on certain accommodations, if you will. I mean, there's a lot of challenges with that statement. I just wondered what that means a little bit more in the eyes of the law.
Okay.
I mean-
And again, reasonable accommodation is described in the context of the real world in the statute later on when we talk about the zoning abilities. But
Okay.
but anyway, Dan, you want to address that briefly?
It's just standard language. The Fair Housing Act requires a reasonable accommodation from these things. We specify the provision in the Fair Housing Act there, 3604F.
Okay, if it's standard language, that makes sense. I think if I was just a day-to-day house manager, if it's described in zoning law, maybe that's where I'm missing it.
Yeah, the house managers are probably never going to have to deal with this. This is
Right.
dealing with between the cities and the community residences and
Sounds
recovery
good.
communities.
Yeah, and this also only applies to housing. This is chapter 419, only deals with housing. This isn't going to address reasonable accommodations in any other kind of issue.
Thank you.
And also house managers are included when you talk about the number of people in a house later on with regard to
if they live there, yeah.
But anyway, okay, where were we? We were on to
8.
8. Okay, recovery community, we were changing agency to entity on line 184. Any other comments? Okay, moving on to 9. It's just the same meaning as in the recovery residence context in 397. So just referencing another statute. 10, which is lines 195 through 204, we do strike through part of that. And again, it includes live-in staff. Okay, any comments on resident? That's standard, basically applying all the statutes that already exist in Florida law. Okay, for recovery for community housing. 11, lines 205 through 209. Sponsoring entity.
No, just to be clear, that's why we just changed it up above because the definition was here.
Sponsoring, well, entity, okay. Yeah, so now is now consistent with line 184.
Yes.
Okay, cool. All right, moving on to the next page, page 6.
Wait, I have a question.
Um,
Are we changing in line 206, agency to entity also?
no.
Okay.
Okay, lines 210 to let's see, taking all those letters in, okay, 210 through 235. Transitional community residents. Any questions, any comments or suggestions?
Yeah, we have to change the language in line 212 to living arrangement of less than 6 months to be consistent. And take out or less.
Of less than 6 months?
Yeah.
Okay,
I guess the same thing down in 231 and 232.
okay, less than 6 months for unrelated people. And what were the other ones? 230?
Does that need to change as well?
Okay, yeah, 231, 232.
Yeah.
Where residency is typically, how do we want to word that? I think
Less than 6 months.
no, is it no less than? What do we do in it first? Want to keep it consistent.
Typically less than 6 months.
Or typically, okay,
There's the other one.
okay. Typically less than. Now, I mean, certified recovery residents can include transitional residences. Oh, but this is in the transitional residence section. Okay.
Right.
Okay. I asked and answered my question. Okay, any other comments? Moving on, any hands? Who? Oh, Dan, you had your hand up or you forgot to turn it down? Okay. Turning to page 7, that's all cross out. So move on to page 8, all cross out. This is the old statute that we're getting rid of, 9. Proceeding to page 10. I'm going to have some questions on this one. Right away, I want you all to be thinking about how this is placed on the page in terms of the numbers and the letters. Because I think we need to change 2. But let's start with 1, 219.002, 1, which is 386 to 400. Any additions? That's pretty standard language, I think. All right. Now, with regard to 2, it looks like 2, 3, and 4 all are on the same topic, which is the exceptions or exemptions. You know, this chapter does not apply to, and correct me if I'm wrong, but 2, 3, or 4, where the local government's land use code does not have certain requirements, then this 419 would never apply because you can be anywhere, anytime with any number of people. So unless somebody has a problem with this, what I would suggest is that from 401 to 416, that we break up 2 into, say, a 2, it will be 2. This chapter does not apply to the following, and then take 2 and make it A, 3 and make it B, 4 and make it C.
Hey, Al, can you scroll down a little bit? Because I see 2 and 3, but I don't see what 4 is. Local government's land use serving or does not define failing. Yeah, all three of these are what Dan's doing rightfully, saying, look, if you meet the definition of family,
Exactly.
right, then this doesn't apply to you.
Yeah, exactly.
Right.
So
Yeah,
what I'm saying from a statutory perspective, construction, or wording and how they
Yeah.
put numbers, I think the 2, 3, and 4 are really one number. So
Oh,
if
yeah,
somebody
I
has a
see.
problem with
Yeah.
that, so
Yeah.
it's going to be this chapter does not apply to, and then to a community residence occupied by no.
2A, 2B, 2C,
Yeah.
is that what you want to do?
Yeah, 2A, 2B,
Okay.
2C.
Yeah, okay.
Al, I like what you're suggesting, except I'm using use the structure here that the state legislative staff used when they rewrote the bill.
So
That's the
they
only reason it's
rewrote it
this
as
way.
3 separate. Okay, well, I'm going to keep the same wording on 2, 3, and 4. And just do that, just put them A, B, and C, and if they change it, they change it, that's fine. I mean, substantively, it's going to be the same. But I just think it makes so much more sense, because if you look at all the numbers through 419.002, and it's the same thing with number 5, and we'll get to that as well, because what you're dealing with is one single issue, exemption or non-application. That would be 2. And 3, spacing distance requirements. You've got 3, I'm sorry, 5, 6, and 6 both talk about spacing distance requirements. And I was thinking that 5 should then become 3. And then it should say, for purposes of local use and zoning determinations, colon, and then 5 would become A, 6 would become B. I just think it just makes more sense. It reads better, and everybody has the context of what we're talking about together in one section. So unless anybody, Dan, unless you feel that it's, again, staff, if they, in their intimate wisdom, if they change it, as long as the substance is there, I just think this is confusing to me reading through the statute. So anyway, unless anybody objects, we're going to do 3A and B. And then let's move to, and by the way, anybody have any questions or comments on the substance of lines 401? We'll take 2 and 3, or 2, 3, 4, 5, and 6, and 426. So going from 401 to 426, everybody okay with the substance? Okay.
Yes.
Right. Let's move then to the next number, which would be, instead of 7, it would be 4. And that's lines 427 to 434. A local government may revoke citing approval of a community residence or recovery community when. Okay. Okay, anybody have a problem with that? Okay, now let's move to 8, which would be number 5 now. Okay. The operator of a community residence or recovery community that fails to obtain licensure certification, may not operate in this state. Anybody, I have a comment, but anybody have a comment before mine? My only comment for both 8 and 9, which would be 5 and 6, is, wouldn't that be subject to 419.004 reasonable accommodation? So wouldn't it be consistent to say, unless, or put something in there about the availability? If you don't have a license, for example, because there is none available, or because or you still have the ability to go for reasonable accommodation, do you not?
We cover that later in the bill.
Yeah, I know. I just these are pretty stark. Yeah, I'm just maybe I'm just trying to, what I'm trying to be is consistent with unless authorized under. We could do that under 419.00, I think it's 0034.
Okay, we can solve this, Al, in the current paragraph 8. I'm not going to try to renumber them in my mind
Right.
by
8 and 9,
saying
yeah.
or a charter available in this state. Just add that after charter before may not operate, and we've got it solved.
What are you putting in there? Sorry, say it again.
In paragraph 8, line 437,
Right.
a charter available in this state may not operate in this state.
Okay. That works.
Al, just to clarify, are you saying that if they lose their certification or if they don't have certification, they could still apply for a reasonable accommodation?
Dan?
No, absolutely
Oh,
not.
okay. I just wanted to make sure. Okay.
Okay. Yeah, the issue is it won't be certification. It won't be any of the licenses that are available. But say an ADA house opens up and there is no license.
Right.
You know, there are disabled people, but it's a disability that is not covered under any of the licensing in the state. That's what this would be a fail-safe
Got
for.
it. Okay.
So if there's a license available, you have got to get it. And again, does that pass muster under
Yes,
under the FHAA?
absolutely,
Okay,
absolutely.
all right. Okay, we have to be ready to defend that. Because there's not even reasonable accommodation available for those types of housing. You know, say, okay, recovery residence that is not certified. They can't go for a reasonable accommodation. It makes sense. You know, anybody can then say, well, I have a manual and I have all the same rules, but it's not the same thing because there's no oversight. Okay. All right. So, and that would be the same in number 6. Well, actually, in number 6, the operator whose license or certification has been denied or revoked may not operate in the state. Yeah, it doesn't apply to that. It's only 5. Okay.
Al, it might be easier for us to follow this if you still use the old numbering system when you refer to a paragraph, because that's what we've got in front of us.
Well, I'm doing that. I'm sorry if I didn't do that. It makes sense in 8, is not needed in 9 because that's somebody who had a license or certification and it was revoked. Okay. And when you say revocation is appealed upon final disposition of the appeal of the denial of revocation, to me, the plain reading of that, because the statute, we had legislation that changed that gave due process to recovery residences so they can go through it to a title, a 20 hearing. So then that appellate process would go up through DCF. So I think we're covered here. Okay. If I didn't make any sense, that's because sometimes I don't make any sense. Thanks for bearing with me. Okay, 446, which would be number 10, now number 7. 446 to 455, any questions about the notification? 5 calendar days. Vacate the premises within 60 calendar days. I would say after date of the denial or revocation, we have to put in the appeal upon final disposition and where denial or revocation is appealed upon final disposition. Anybody think that that's not needed in there?
I'm troubled because obviously when FAR or a state agency denies a license or certification or a license or revokes it, they're doing it because the people living there are not being protected, are at risk, and these are vulnerable populations. So I'm just not quite sure that they should be allowed to keep operating if they've been denied or revoked while they're appealing. But I'd like to know from the people that operate these or run these what they think.
I think we should ask Michael Schlossman from FAR, who's developed over a year policies and procedures on this very issue.
Yeah, so if they're suspended, that's one thing. They're no longer certified. If they're revoked, obviously they're revoked and they're no longer certified. But if there's an appeal, we do hold it open. Their status is somewhat in question. They're not certified at that point. So I would agree with you, Dan, that it is concerning that what do we do with these clients? What do we do with these residents that are there? And
Well, why don't we put a period after such operator must cease operation, period? As far as vacating the premises, that's neither here nor there. They can't operate.
Well, Al,
Now, if they win the
I'm not
appeal, that would be reversed.
right. Well, and here's, I agree with what everyone's saying. The question we're trying to figure out is that if FAR makes a decision to suspend or revoke, and they've developed procedures about appeals, what if that revocation or appeal is overturned? At that point, we've shut down a house, and then a appellate body deems it to be erroneous. And now you've had to relocate all of these residents who probably are patients in a treatment program and possibly lose the establishment of that location in a spacing paradigm. So it's unless while we put language in there,
Perhaps
unless
we
it's
could
for
put something about
Hang on. Do
stop.
not interrupt. Just raise your hand.
Yeah, what if we put language in there unless there's a finding, and I don't know what DCF or ACA does under the same circumstances, right? Is what do they do when they want to suspend because someone didn't file a report right, or is it a life, health, safety issue, which is what Dan and probably Susan and FAR are concerned about. So how do we thread the needle on that?
Okay, 10, by the way, 10 does not talk about suspension. It's only denial or revocation. So go ahead. We'll, in order, I think, Sam, you had your hand up, and then Susan, and then Dan.
So I'm gonna agree with Jeff on this one. What we're looking at here is I have two questions. One is my only request would be for 447, line 447. I would put official or entity, because sometimes it is an entity as opposed to a direct individual. And then in reference to the 60 calendar days, my question would go to Michael, and I don't know if anybody from any of the other larger state agencies are on the call, but my question would be, what is a typical amount of time for an appeal? And I think it should be no more than whatever X is. Those are my thoughts, because going to what Jeff was saying, if it's a misfiled paperwork and they're in revocation or denial, but they're appealing it, and it is something as simple as a report, you're going to displace residents in a program, and which may cause more of a disruption long term than the short term gain of, well, they are going to be revoked, therefore they're going to be denied, therefore they should be shutting down. Because probably my guess would be there's probably more egregious cases as opposed to less egregious, and something simple. And if they're appealing, then I would defer to that.
Okay, Susan, you're up next.
Yes, I agree, because no one knows, even though we're in the middle of some appeals, how long that process is going to take. So I think there should be some amount, and we're not in control of it, far as DCF is in control of it. So I would suggest pending, an appeal, and it should be in abeyance, because, for constitutional principles, they're allowed to appeal, and theoretically, if we're reversed, they could be in this situation where, what you've all adequately described as a problem. So I do think there should be some language about appeal. But however, I can't tell you how long that is since we don't have that much of an experience. I mean, we're in a multi-month appeal right now.
Okay, before I go to Dan, who's got his hand up, here's a suggestion. That we do put in the appeal process in number 10.
Okay.
But then we say, unless the health and safety of the residents or the community, the language that we have later on we have a separate section that talks, there has to be a mechanism for, whatever department is overseeing, whether it's the DCF or FAR or whatever. If it's an emergency, they're going to stop operating if the health and safety of the residents are at issue. So with that, let's, Dan, please let us know what your thoughts are.
I think you've got a good point there. We have to keep in mind this is not governing just recovery residences. It's also covering group homes for people with developmental disabilities, mental illness, physical disabilities, the frail elderly. And I think what you're suggesting in health and safety makes sense. I suggest that we take this and not try to craft language right now, but come up with language that will meet these concerns.
Okay.
Yeah, let's put a pin in this one now and talk about it later, maybe.
I do have a suggestion.
Okay, hands up, but go ahead. You got your hands up, Michael.
He did have his hand.
Yeah. In line 450, the denial of revocation, can we just add and completion of any appellate process or successful completion of appeals?
Yeah. Here's a couple things. I got word from Gail Harrell that we need to get this into drafting. Last year, we never had a bill because we got it into drafting too late. And by the time we got it back from drafting, we could not go back and forth and create a bill that they were satisfied and that could be worked. So with all due respect to, let's table it. I'll stay here till 7 o'clock at night if I have to, but we won't have to.
Okay.
We're already halfway through the bill, and I think we can work out language. Now, with that in mind, if we can make a better mousetrap, we can go back in with tweaks from our meeting that's coming up on September 10th, where we come up with final language. I want to make this the best it can be because it's got to get into drafting. So if everybody's okay, please, let's work out language as best as we can and then move on. Now, Dan, you have your hand up.
Yeah, Maureen Killian in the chat noted that while appealing may be mandatory secondary supervision by FAR, or I would add the licensing agency, might be something we want to put in. And she does urge that we limit the appeal process length because lawyers can stretch cases out to 10 years. I'm not a litigator, so I don't know, but it could get stretched out. Yeah.
Okay. Those are good points, but we can't deal with the appeal length in this legislation. But again, if we put in the caveat that each of these licensing or certifying entities can, if the health and safety of the residents or community stop operation at any time in an emergency, I think, during the appellate process, because again, 10 only deals with denial or revocation. Okay, it doesn't deal with suspension.
Right.
9 deals with the ability to operate. Okay, and the null and void when there's a termination of the license. And again, when denial or revocation is appealed upon final disposition of the appeal. I think in both 9 and 10, we should look to the language that we have later on. And maybe, Dan, you know exactly where it is in this, in the 21 pages.
Al, before you get there, my hand's raised, but what that language you're talking about is FHA language, which says you don't have to grant a reasonable accommodation to people that are basically a threat to themselves or others in the community.
That's the general language.
Yeah, no, I think my recommendation here is to leave not to leave upon final disposition, and then put unless there's a threat to the health, life, or safety of the residents,
Well-
period. And then let legislative staff tweak it.
Yeah.
You know, just put it
I
in
ju-
there and let them figure it out.
Yeah, I
at
just
least-
want to
yeah,
say
go
a
ahead.
quick note, Jeff, on that, because I agree with you. The problem is that if we're suspending or revoking, there's a pretty damn good chance there's life,
Right.
health, safety issues going.
Exactly.
Right.
Yeah.
Right. But not in all instances, right? It's probably
Not in all
90% of the
instances,
time.
no.
I think if we
Exactly.
just add upon final disposition appeal, unless the health, life, or safety is threatened, and just put that language in there and let legislative
Yeah.
staff tweak it.
There's
to-
also
to-
something about the community as well in there of the health.
That's
safety.
FHA language. Yeah, that has to do with that's why there's no protections against people who are in recovery that are violent criminals who just got out of jail. You know, that was the balance when they did the FHA and the amendments and the ADA, was to say, look, we're going to let you do this, but if the person's well, we don't want dangerous people in our neighborhoods, and so that was the balance that was created. So those people already are not entitled necessarily to any of these privileges because they're not deemed a protected class.
Okay. Where is the language that we were talking about? I'm looking through here and not seeing it.
Yeah, Dan, where you know
Oh,
what I'm talking about.
Direct threat to the health and safety of other persons or whose residency would result in substantial physical damage to the property of others. Why don't we just pull that language
You can
out?
pull that up there. I mean, Dan, what do you think about that? Is that okay?
What are you proposing?
Okay, so
Dan?
here it would
Yeah.
read, let's take 10. Okay. It would read, if you go to line 454, within 60 calendar days after the date of the denial or revocation. See, I'm not so sure we should put in vacate the premises. I think must cease operation.
Okay.
And then we would put in the language, like we could say when denial or revocation. No, wait, okay, hang on. I got this. I just got to get my brain operating. Okay. All right. Let's do 9 first. That's easier. When denial, let's do 9 when we're getting to 443 to 445. Okay. Zoning approval is deemed null and void upon termination of such license, certification, or charter, or when denial or revocation is appealed upon final disposition of the appeal of the denial or revocation,
Okay.
unless shit, I just had it. Okay. Why don't we just put in, this section does not permit the persons to occupy a recovery, unless, okay, may not operate in this state. And zoning approval is deemed null and void upon termination of such. You know what? I think we can leave that one alone.
Yes.
And I think we go to 10 because that one is much more sensitive to the revocation or denial. So revoked within 5 days after the notification of denial or revocation, which is line 449.50, such operator must cease operation. And I would just put a period there and take out and vacate the premises. Because it might be a house and the person owns a house. I mean, why it's you stop operation. Okay. Now, after the, okay, and stop operation upon, okay. Within 5 calendar days after the notification of denial or revocation, the operator must cease operation. I think what we do is we put this language in on 450. So revoked within 5 calendar days after operation, after the notification of denial or revocation. Period, when denial or revocation is appealed upon final disposition of the appeal of the denial or revocation, unless the health and safety, and we use that language there. Does that make sense? I can repeat it. Carol, you have your hand raised.
Thank you. I think that was a good attempt, Al, but it is a little wordy.
Right.
My suggestion would be something along the lines of enforcement shall be stayed pending outcome of the appeal unless the denial or revocation is due to a life safety issue.
That sounds good.
Because I'm thinking of local governments, and if they're going to be enforcing this, it's got to be plain language and simple as possible.
So the enforcement of denial, a denial or revocation.
So
Repeat that.
enforcement shall be stayed pending outcome of the appeal unless the denial or revocation is due to a life safety issue.
Of an appeal unless it says the second part of that.
Unless the denial or revocation is due to a life safety issue.
Unless the denial or revocation involves
That's fine.
life safety issues.
Or health safety issues, however you want to define it.
I think it's health safety issues.
I think life safety is the proper term.
Okay. Okay, so it would read then. We take out from 450. Okay, from 450 to 452, we take that out. Community residence operator or operator must notify the designated local government official or entity that his or her license, certification, or charter has been denied or revoked within 5 calendar days after the notification of the denial or revocation. Enforcement of a denial or revocation shall be stayed until the outcome of an appeal unless the denial or revocation involves life safety issues. Everybody okay with that? Do I need to add more to that? Hands? All right.
That sounds great.
Thank you, Lori.
Oh, the only question I have is procedurally, what if the fact that it's a life safety issue under FAR's determination, but that's the subject of the appeal?
Doesn't matter, because if it's a life safety issue, you have to, that's the caveat. Who decides it's a life safety issue? I mean, it's an imperfect art.
Yeah.
And Al, someone could always run to court if they absolutely had to, if they're having a dispute. And in the rare times that it's really going to be an actual dispute, run to court and get a temporary injunction. They had to.
Okay.
Listen,
I mean, it's really because FAR's not, in my experience with FAR and Michael, they're not only beyond fair and reasonable, but they're trying to fix problems. And if someone's gotten to the point where they're suspending or revoking, that guy probably has no business running a recovery residence anymore, because probably it's really bad environment. So if that person wants to push the envelope, let him go to court and hash it out in court, and let a judge make the decision, so that FAR and everyone else doesn't have egg on his face that they didn't do their job.
Okay.
Now remember, this is numbers. Okay. We don't talk about suspension here. None of this talks about suspension.
Right.
It's only denial or revocation.
Right.
So suspension sometimes can be worked out. And I believe there's a catch-all that if it's life safety, it's life safety. I mean, DCF will come in, and if it's life safety, they'll shut you down.
Right, that's my point. If they want to, and then if they did it erroneously, you got to go deal with legal action. But at least they're protecting the residents and the public, which is, I think what Dan was expressing from the get-go.
Okay. All right. I think we've got this one pretty much figured out. Any other thoughts on Terrell? You still have your hand raised?
I do. I just was wondering, are we going to keep in the 60 calendar days for if it's a life safety issue? Because even though it is an emergent issue, we don't want to make people immediately homeless. Or do we want to put in a different time period?
Again, I have a problem with the 60 days because if you're vacating, it's different than you're getting placing all the residents in there. If you own the house, do you have to vacate the house? If you're a renter in the house, you can still rent if you want to stay in. I mean, do we need to vacate the premises when you cease operations?
I
You can
think,
take it out.
yeah, I think you do, because otherwise people are not, the people that are wanting to enforce this, that we're trying to make it easier for them to understand and for there to be a consistent standard across the board throughout the state, are going to be confused by the cease operation. And I worry that they'll expect an immediate vacancy. And that's just not logical or ideal. Again, we don't want to make people homeless immediately.
Yeah, that's the worst case scenario, is putting people on the street or relocating them and disrupting their recovery.
Well, it's 5 business days, so it's not immediately upon the revocation or denial.
So,
No,
yeah.
no, Al, the 5 business days only has to do with notification to the local government.
Okay, well, if you all want to keep in the vacate the premises within 60 calendar days, that's fine with me. I just see a potential, and if you cease operations, that means you're no longer operating and that you should not have residents there that are disabled, in a community residence. But okay, we'll leave it in. Again, we can tweak this later on. Okay, I think I pretty much got it. Now move to number 11, 456 to 459. Oh yeah, actually we can go to 11, 12. These are grandfather clauses. If you're already operating, you're already operating, right? On 11 and 12, which is actually 8 and 9 now. But lines 456 to 462, anybody have any issues? Hands?
Hold on now. Yeah, hold on. The only, and I tried to discuss this with Dan, and maybe we'll do this another time. The only limited concern I have, because it's happened, is when you have, it's that when you have a structure where, I mean, a government paradigm, a zoning paradigm, where you're otherwise operating, there's no laws, you're operating, say, sober living, or you're in something that will become a recovery community, and there's no local requirement for a business tax receipt, there's no local requirement for anything, you've been doing sober living forever. We create this new paradigm. People don't know, and Dan and I have talked a little bit about this. People don't know that there's no process. People don't know you have to apply to establish yourself. And so what I had recommended is that if somebody is, and this was what was put into the Palm Beach County ordinance that I had provided language, that let's at least give people, like I say, they're not legal non-conforming if they were operating, but how do we know if they were established or not? Because if they weren't, quote, lawfully established, which is a zoning term, then the city or county can say, well, you weren't lawfully established, so you're not legal. You were always illegal because you didn't register. So I'd like to see if we give people, at least like we did in Palm Beach County, a year. One, you had to be FAR certified as of the date of that. Two, you had a year to come into compliance with the local application. And that gave everyone time to go, hey, you got to go do this. And, FAR, we hope, at the time, FAR notified its members, hey, if you're in the city, you have to do this. So what happens otherwise, by way of example, is if you have, say, an apartment building that has, that each unit is meeting the definition of family. There's, say, 3 or 4 unrelated people per unit, and they're fine. Now they're a recovery community. I know there's a thing that you can't be ignorant of the law, but my experience is that these people don't know that they now have to go register, and the city otherwise didn't know they were there because the city didn't require, say, a business tax receipt, like a landlord permit. Then when they go to become compliant, go, oh, I didn't know about this. Then the city says, sorry, you didn't register in time. You now can't be there anymore.
So,
And all it does is encourage people to stay underground versus to come out later and go, oops, I didn't know. I'm sorry.
so are you suggesting that we just add on to 11 and 12, provided that within X amount of time, they become compliant with the requirements under this section?
There was language that we wrote when we were doing Dan's version of the Palm Beach unincorporated Palm Beach County Code. That again, I don't want to take everyone's time. It's there in black and white. You know, you're grandfathered in so long as you've established yourself lawfully, and we're giving you a year from the effective date of this ordinance to come into compliance. But you had to be FAR certified. If you were never FAR certified, then you don't. At least that's the way that was written. Then you don't even get the benefit of the doubt on that. I'm not saying that's the right way to do it. I'm just saying that's how Palm Beach County wrote theirs, and there's probably other cities, Dan's aware of, that wrote theirs that way too. I'm
Well,
sorry, my camera's off. I didn't mean that.
I see.
I mean, it's how do you prove you were established is what ends up. If you had a reasonable accommodation, then yeah, they know you're there.
Okay.
You know.
All right. Now I know Sam had his hand up, but I'm going to call on Dan first to respond to Jeff's concerns. What are your thoughts?
Okay, the what we did in Palm Beach County and a dozen other cities is we've allowed a certain period of time to get certification. This was aimed largely at the uncertified recovery residences. And it was solely to get your certification. It had nothing to do with being grandfathered in. Like the language here in 11 and 12 actually is from the state legislative staff. I don't see the problems that Jeffrey's describing. I think they're theoretical largely. I think an operator could show that they have a zoning permit, they have an occupancy permit. There's all sorts of local zoning permits that they could show that they have. If they're, I just don't see any need to adjust this, but maybe Sam has some suggestions here that might be helpful.
Before I go on to Sam, was the language in 11 and 12 language that the staff, legislative staff put in, or is that your language?
I think it's the language as changed by the legislative staff. I'm not 100% sure.
Okay. All right. Sam.
As maybe a way to bridge this to addressing both Jeff's and Dan's concerns is maybe you push the effective date out on this specific sections to maybe like October 1 or January 1. But simultaneously, instead of saying lawfully permitted, you say lawfully permitted or something on the lines of or applied for. So that way, that for any residents going to Jeff's original point that's been operating, they're doing everything above board the way they traditionally have been. But they were unaware. And again, ignorance of the law is not an excuse. However, what you could say, like if they've applied for, you make them aware, you push out that timeline. They have to have either applied for or have it by said date, but at a minimum have to have it like applied for. That would be my suggestion. Because again, like if we put them on notice, hey, listen, y'all have, because July 1 is a tight timeline. However, this session does end like March 13th. So the same timelines that apply in a normal session would not be the same here. So if the session ends on time, we'll have that traditional 5-month window. So July 1 may be appropriate, but also you have something as in applied for. So that way they get looped into that window. And I don't know if it accomplishes the goal, but that was my thought process.
Well, I think that the certification process is pretty quick now. Maybe we should push it off to October 1st, which is about 6 or 7 months. Michael?
Al, may I suggest to January 1st, 2027? That would certainly give everyone the opportunity to get their certification or licensing.
What does this do to a residence that's operating and they're certified or licensed, but they're within 660 feet? I guess they're lawful because they to be certified, they would have had to have complied with local zoning laws. Okay, so I've answered my own question. So if we pushed it off to January 1st, we don't have to do the application dance, because sometimes people apply and then they just string it along forever. I don't think that happens as much now. But Michael, is that something you would recommend? That we take it one 6 months beyond July 1st?
I'm just hoping 6 months is enough, but I think we could make that work.
Okay.
Yeah.
Yeah, I mean, there are certain fires that you put in front, right, to put
Right.
out. I think that gives you literally
Yes,
eight
let me
or
correct
9
what I said.
months.
6 months is enough. Yes.
Okay. That'd be 8 or 9 months from the end of session.
Yeah. Thank you.
But the governor, it might be less because the governor might not sign it into law. I'm really being optimistic by, June or something. But anyway,
Ooh.
okay.
Then maybe we push it to October instead.
No, I think January 1st, 2027 should be enough. And number 12, 460 to 462 does not affect the authority of any community
Hold
resident.
on, Al,
Yeah.
Al, I have my hand up on this issue. We're not done.
Okay, go ahead. I didn't see your hand up.
Yeah, I was going to say something, but I bit my tongue. I don't think it's fair that I'm the only person in this room who's ever had to deal with these ordinances, ever, for the past almost 10 years, right? And for someone to say to me that my concerns or questions are either anecdotal or speculative or not realized is not only personally offensive, but demonstrates a lack of understanding that this entire paradigm is theoretical. I've experienced it. I've had to do basically free legal work for these really nice sober living level twos who are getting squeezed by cities who don't understand it. So when I say, hey, how do we prove someone's been lawfully established? Hey, they don't have a business tax receipt. Hey, they don't know. And to be told that I don't know what I'm talking about is highly offensive because the only person in this room who's going to be dealing with this ordinance is me. Right? And so, wait, so when I say something, and I've been saying something for years and make comments, and I'm being told, hey, give us examples, I have nothing but examples. And I apologize for getting animated. But really, I've been a part of this task force since before it began. I've been writing legislation with Terrell to correct industry before this task force was founded. So to be told, I don't know what I'm talking about is highly offensive to me. Because what happens is cities don't know about this. And all they do is they don't give their best planners to review this. They don't educate people on fair housing. They find candidly the people that they trust the least that they're not going to give a very large development project to, like GL Homes. And they go, here, you go deal with this. And they don't know what they're doing. And when you go, hey, look, and Dr. Moran, who's not here, is a perfect example. He had no idea. He had multiple duplexes all in a community. They were fine. That's where his residents were living in their transitional program. He didn't know about the recovery communities. He didn't know about the law. He had 4 unrelated people per dwelling, which Dan said was a way, in all his studies, was an ulterior way to get around the law. Like, no, they met the definition of family. And so they were allowed to be there under my legal advice. They met, and even this code says, hey, if you meet the definition of family, you're good. But now we create this recovery community. So you have a lot of recovery communities because the vast majority, I think, of beds in Florida are level 4s, which are going to be in a recovery community, in a multifamily setting. They are not going to be aware of this. And they're FAR certified. It's not about being FAR certified. I don't care. I care, but it's about putting them on notice that they need to go apply for this. Because if they don't, and then later they either get cited for code enforcement or want to do something, they say, sorry, you never lawfully established yourself. So if you read lines 456 to 459, those are for lawfully established uses. You can't be a legal nonconformity if you were never lawfully established. And these uses are lawfully established. There just isn't a vehicle to put them on notice. So I think that I get it, we're talking people need to be put on notices. We're talking fair housing. We're talking housing laws. We're talking people in recovery. That I think we should err on the side of caution. These cities, no differently than they're required to put notices in City Hall about reasonable accommodations for other things. Every city has a code for reasonable accommodations, at least, or for ADA in that way, right? I think that there needs to be some kind of notification to let everybody know, hey, you have until this time to come into compliance across the board with everything. If you've been, and how do we prove that they've been there and aren't just like raising their hand? I'm like, just if they were like it's 2025. If they've been FAR certified, then great. If they're not FAR certified, then that's not my problem. But again, when I make a comment to say that it's anecdotal or speculative or I'm just crying spilt milk, I don't do that. And so I don't like that the singular person who's always been here for 10 years to represent the private side of the community is being told we're not listening to you because what you have to say is speculative, as opposed to the majority of the beds in the state. And the majority of the beds in the state are level 4. They are tied to treatment and they're doing really good work, right? That's why I got upset at Dave's book about blowing up the Florida model. Florida model came from Minnesota, from Hazleton. So I really think it's important that everyone be put on notice. Hey, there's a new law in town. Please come apply. And you have a year to do it. How do we know you were there? Well, if they didn't have a business tax receipt, if there's no landlord permit, and Terrell can speak to this. If there was no other way before to seek a zoning approval, because Dan said, oh, everyone needs zoning approval. That's not true. There's lots of cities that don't require zoning approval for certain things like housing. And so we need to give these people time to be educated and come into compliance and just apply. Here I am, because the purpose is to put them on a map so that the city in the future can start spacing them out. And while grandfathering in the ones that have otherwise been there doing the right thing, have been compatible with the neighborhood and consistent, they just didn't know that there's a new law in town. And that's what I've been dealing with for 10 years.
All right, Jeff, there's a lot to unpack there, and I'm going to
go. I took offense to it. I'm being serious. That's not right.
Jeff, I didn't hear the words you heard. I'm sorry.
Well, you're recording it. You can play it back.
I'll listen back, but I got to tell you, just like
Al, I was quiet the whole time to wait for that. I know what I heard. If you want to stop the meeting and play it back, we can do that.
I am not doing a replay. Jeff, your input is important. You've already had a seat at the table, and many of the things that you wanted to see happen are coming to fruition. Just like you said, Dave, stop fighting the old war. Please stop fighting the old war. But to the point that you made, when you got to the end of what you said they need notice. Fine. Is January 1st, 2027 not sufficient?
I think that's more than ample notice. I don't know if they need that much time, but I defer to everyone else. It just has to be reasonable.
Then what do you, I don't, okay.
What? No, because you're saying notice to get FAR certified. It's not about FAR certification. It's about even knowing. It's not that they need a year to get FAR certified.
First of all, if you were lawfully permitted prior to the passing of this legislation, and you weren't, as a matter of right, in there because there was no cap on adults, et cetera,
right.
You probably are already lawfully permitted. I mean, you're there, you're FAR certified. FAR certification requires that that the zoning is proper.
No, it does not. No, it does not.
All right. So, in the interest of time, Michael, do you see a problem with letting every FAR certified recovery residence know and understand? Can you send out, the cavalry to let them all know, like we're doing with Matt, what they need to do if they need to do anything?
Sure.
Okay. So I think we got it solved. Jeff, I didn't hear anything that was personal to you, but you heard it, so I give you that. Let's move on. Anybody else? I saw that Sam Wagner, you had your hand up, and then Dan, you have your hand up. And I will not permit a back and forth here. Jeff, you've had your say. You are respected. And if somebody says something, take it offline later on. Let's get this done. Sam?
So in reference to Jeff's point about notice, my only question is, to his point, who is, and this goes to the group, who is the expectation that would be providing said notice? That would be my broader question there. Is it the local government's duty? Is it FAR's duty? Is it the state's duty? That's my question in reference to notice. That's what I'd be curious to know.
Okay. The context that we have been involved in for the last 10 years is recovery residences and the 397 space that is behavioral health. So there are other agencies involved. So when we say FAR will give notice, that'll only be to recovery residences. When you're talking about, other types of disabilities and other types of agencies, we could put in here that licensing and certifying entities are required to give notice of the requirements of the statute. I mean, that's kind of bad wording, but maybe something like that. I don't think it's necessary. I don't even think it's necessarily if we have that much time for recovery residences. If you're already licensed or certified, and it's interesting because if you have somebody who's certified, let's talk about a recovery residence. A recovery residence is certified. What else do they need to do to be lawfully permitted? So, for example, if they're within the spacing, outside of the spacing distance, all they need to do is request a permitted use. If they're inside, they'll have to go for a reasonable accommodation. It's not rocket science, but there might be somebody out there who just has got his thumb in his ear or her ear and doesn't realize this. I don't know that we have to make that big a deal about it, because the only ones that might get caught in this lawfully permitted would be somebody inside the spacing distance or somebody who has too many residents in the house. And those would have to have a reasonable accommodation anyway, inside the spacing distance. So Dan's got his hand up, and Dan, maybe you can assist if this is a major problem and how we can fix it. Sometimes less is more.
Yeah, it's not a problem, and people are not reading the language there. 11 and 12 are referring to community residences. It is not referring, neither one is referring to recovery communities. If you have a city or a county that did not have anything about recovery communities in its zoning ordinance, and say it had a definition of family that allowed 4 unrelated people to live together, if you have an apartment building, you put 4 people in recovery in each unit, that is a lawful non-conforming use. They would be allowed to continue.
But how do you establish and prove that existed
You
prior to the
show what
law?
Jeffrey, you show what the zoning ordinance was at the time that they occupied the building. That's all you need.
Makes sense to me.
Yeah, I know that's all you need. That's just not how it works, but okay.
All right. Well, we have enough time here in terms of January 1st, 2027. We're gonna circle back if we want to tweak this. We can circle back on the 10th and discuss it further. But unless there's some other hand up wants to speak, let's move on to page 12. And that's number 13, 463 to 467. Okay, that's the direct threat to the health and safety of other persons or those whose residency would result in physical damage to property of others. This is the longer way of saying what Terrell said in the earlier section. That's pretty standard. Any questions, concerns, comments? 468 to 473. Does not require a local government to adopt a new ordinance if it has in place an ordinance governing the placement of community residences that meet the criteria of 419.03 and 419.004. Okay. And of course, local government can adopt less restrictive zoning for citing recovery communities. Terrell, I wanted to ask you a question. Is regarding home rule. I forget the term. But how does this compare to the statute that's in place right now? And, do local governments still retain the power over their own zoning ordinances?
Yes, so excellent question. The existing Chapter 419 provides very similar language. So this proposed language tracks with the existing statute, So there's no new preemption being imposed here. It is just that the statute in this instance is bringing Chapter 419 up to current day standards and requirements to comply with the Fair Housing Act. So again, I want to be clear, there is no new preemption being imposed here. This is a situation where it's just that the law surrounding it is being brought up to current day standards regarding the Fair Housing Act. That said, it does say that nothing in this section prohibits a local government from adopting less restrictive standards for siting. Presumably, if they have no standards, I believe that would be okay as well. The point is they just cannot adopt more restrictive standards for siting because those would very possibly be or would very possibly run afoul of the Fair Housing Act. So this is almost like kind of the minimum standards to comply with the Fair Housing Act. And it's meant to provide that kind of guidance that has been lacking in state law.
Thank you, Terrell. Dan, you have your hand up. Dan, you have your hand down.
In line 473, we should add for citing community residences or recovery communities.
Well, this is in the section that deals only with community residences, though.
Right, but we have, as this is currently written, it's recovery, it says for citing recovery communities. So I was suggesting
Okay.
we have
He's
both
saying
of them.
he's saying it's an editing snafu. It should have been there the first time.
Yeah.
Oh, for citing recovery. Oh, it should be out or in. Oh, it should say recovery.
Residences
Recovery,
or recovery communities.
It should say recovery residences at the end.
Or yeah.
Okay, residences. Okay, good catch. Okay, let's move on to section 419.003. Community residences permitted use. 476. Let's just do it one section at a time. 476 to 481. Allowed as of right in all zoning districts where residences are allowed as of right. Okay, 482 to 487. Transitional community residence constitutes a residential use allowed as right in all zoning districts where multifamily dwellings, duplexes, triplexes, or other forms of multifamily structures are allowed as of right. Okay. Good. Dan, you have your hand up.
I want to make this real clear. What this does is you've got a lot of jurisdictions that put a label of single family zoning on a zoning district, but they allow duplexes or triplexes or townhouses in those. Transitional community residences would be allowed as of right in those districts. And the only ones where they wouldn't be allowed as of right are districts that are strictly single family detached housing. I want to make sure that is absolutely understood.
I think that's pretty plainly put there.
Good.
Anybody
Okay.
have a question about that? Okay. 488 to 493. This is the distance spacing, and you have on 489 within a radius of 660 feet or 7 consecutive parcel lots. Now I know in the study it was 9, and I congratulate you and Jeff and Terrell working together separately, but together with you on reducing it to 7. I think that's correct. When you're looking at a block, it's more in line. It may be a little more, maybe a little less. Obviously, it's different in urban, suburban, and rural. You go out to the acreage here in Palm Beach County, and 7 consecutive parcel lots is going to be a lot more than 660 feet. But again, it's the density of the use. But I thank you for bringing it down to 7. I think that's appropriate. Anybody have any questions or concerns? Raise your hand, please. Okay, let's go to number 4, which is 494 through 501. Um, wait. Oh, and I don't think that should be 4. I think that needs to be subsection A, B, C, and D, or A, B, and C. Does that make sense? Because you have 3 as its own section, and then you have 4 as its own section, but that's a qualifier to 3.
No, that they are separate. That we've got 3 basic standards: the spacing, the licensing certification, and a cap of 12 people.
Okay, then it should be 3A, B, C, and D. Because if you have 4 separate from 3, it's now gone to a new section. It's not part of 3.
As you wish.
Okay, so I need suggested suggested language in 488 to start 3 off, or we could start off 3A, and then the legislative staff will just change it. So make it 3A, the proposed community residence spacing distance. Make 4B, and then make A, C, and B, D. Okay, so the combination of the 4, wait. Should we take 2?
Why don't we renumber this after this meeting and put in the new draft?
Well,
It's just a technical issue.
I'll renumber it. Yeah, and I'll send it out tomorrow. Okay, all right, let's go to 5. Starting on 502, ending on 505. Anybody have any issues with that? And this is community residence for permitted use. Let's move on to section 4, which would be 419.004. And that's the reasonable accommodation for community residences. Does anybody have any issues with lines 508?
Al, can I just go back to the other one for a second?
Yeah,
So
sure.
does that mean that anything above 12 would require a reasonable accommodation?
For a community residence, yes.
Okay. Does that is that number 12 something from federal law, or is that something we agreed on? Where does that come from?
Well, I'll let Dan give his reasoning, but I will tell you, we need everybody on board on this bill. A community residence is a family, and one residence is generally thought of as a maximum of 12.
Okay.
And, you know, once you get beyond 12, again, what is it? Is it a dormitory? I mean, again, we can split hairs and we can talk about, you know, the larger issue, but that's why we have recovery communities, and everything is subject to a reasonable accommodation. And I know Jeff has been through the tortures of the damned with reasonable accommodation. I think this bill does a pretty good job, at least of giving a leg to stand on if you have 14 people to go in and say, you know, but right now 12, and it's a matter of right. You know, it's a permitted use. It's a sea change. So we got to be, you know, careful that we don't overreach in some of these things. And we want to get a marriage between the League of Cities, the Association of Counties, you know, the advocates for more housing, FAR, and the community, like the Delray Alliance, that, you know, wants to do the right thing, but doesn't, but may have apprehension if the places are too big.
And Al, when we did reasonable accommodations, and we always have zoning experts and housing experts, and also recovery experts, not inexpensive, that's really a lot, have always said that the sweet spot for a large recovery residence is 12 to 18 residents, depending upon the layout and the structure. And so when we talked about it, even in Florida, the average large home in Florida is a 5-bedroom, right? So that's 2 per bedroom. You might be able to get 3 in there depending on the square footage. There aren't many 7-bedroom homes, and at the same time, Michael, we were talking about FAR and we call it potty parity, bathrooms and stuff like that. So it's my understanding that, and Dan, please correct me if I'm wrong, that the reasonable accommodation standard for above 12 are not the standards here, but the traditional standards of whether you're undermining the zoning scheme and, is there a therapeutic necessity and or financial necessity to have more than 12?
Right.
So going from a permitted use as of right to, today, these are not as of right. So you take a permitted use as of right, we took the minimum amount that even NAR and Science, Steve Polson and those have said, the minimum amount that can be a family that really works in this space is 12 to 18. And so we went with 12.
Okay.
Is
I
that
think you meant
okay for you?
the maximum amount, right?
Yeah, I'm sorry. Yeah, I meant that's what I meant. Well, no, because you can seek more through reasonable accommodation. We're saying the maximum number of permitted as of right. You thought like the median number of homes in Florida, how many homes are there that are actually larger than 12? Because you can get under this, you can get 12 in a single family neighborhood, as of right. So it was threading the needle between what therapeutically works, what does the science say, as opposed to when does it just start to come across that, it's just too large.
Okay.
And all that makes sense. Is there any, and if the answer is no, it's okay. Is there any way to tie it to home size?
Well, the only way it's tied to home size is by the amount of square footage.
No, and Al, the reason we don't want to do that is because it is the argument that's a fair argument. No one's going to do this, but it's a fair argument. So then if I build a 10-bedroom house, I get 20 people?
Yeah. Yeah.
No one's going to do that. That's anecdotal. That's never happened in my career, but the League of Cities always brings it up. And so you have to acknowledge it, that what do you do if someone buys a house on spec, they can't build it, someone comes in and goes, hey, I can use this as my community housing location and put 20 people in there, because it's a 10-bedroom home. It's that.
Yeah, Jeff, one of the reasons I'm asking is for a bunch of reasons, but I'm thinking back to my last recovery residence where we probably could have put 24 people in there and still had plenty of room for spacing. And there are other places like that. So I was just wondering if 12 is one of these magical numbers, like 660, feet, or is it's something trying to fit within?
Well, no, but Michael, if we were to bring the social scientists in, at least the experts, there are very few experts who, as you saw with the Mandy's hearing, that will testify as to what is effective recovery in housing. But if you bring people in, I have yet to find someone, and I'm not saying it can't happen. It can always happen. I just have yet, as a lawyer who, with evidence, have been able to find someone to say that 24 people in a recovery residence, that they can actually function and emulate a biological family.
Sure.
It just becomes too big.
Yeah, I was in those hearings with you, right? And they
right.
And by the way, this is only for single family, right?
No, this is for all. Well, it's all community residences. Obviously, in a recovery community, an apartment building or a duplex, or whatever. Look, if you can, if you can get somehow magically 12 people, on each side of a duplex for 24, there is no limitation on the number of people in a recovery community.
What if it's an apartment building with 60 people in it?
But each unit, right, because that's different. Because each unit, though, each dwelling unit only has, let's say, 4 to 6 people. Here, we're talking about a singular dwelling unit.
Oh, I got it. Okay.
Right,
so,
a singular
in an apartment building, it would be
doesn't matter, right? But what Dan's created is saying in a singular dwelling unit, because a multifamily structure has multiple dwelling units, right? So yes, we're talking mostly overwhelmingly detached homes is what you're talking about. But if we had a townhouse, and let's say there's 4 townhouses and each one has 5 bedrooms, and we can put on 2 per bedroom, and it works from square footage, and FAR is okay with the bathrooms. That's a recovery community. You can put 20 people in there if it works, but it's not realistic.
Sure.
Right.
I understand. As long as the apartment building is separate dwellings.
That's separate dwellings. Right.
Okay.
Dan, you have a hand up?
Yeah, you have to go back to the legal history of court cases involving group homes. The underlying reason that courts were requiring group homes to be allowed in residential districts, including single-family districts, even before the Fair Housing Act was amended in '88, was because these emulated a family. And we're talking about 4 to 8, 10 people. We can feel very confident that 10 people can emulate a family. And that's what the number I've been using to be a permitted use until about 2 years ago when we upped it to 12. Beyond that, you really got to do a case by case review to see whether it's really going to be able to emulate a family. So that's where the origins of that. But, you know, as Jeffrey pointed out, the recovery communities are larger communities and they can be 200 people maybe, but they're not allowed in pure single family districts. So that's the origin of it. It's not arbitrary. There is a basis for it.
Okay, got it.
Okay.
Thank you. I appreciate that.
Let's go to 419-004. I want to bring up something because I know I want to discuss this. But we'll go from lines 508 all the way through to number 2, which would be 541, so 540. And my question is this. If we are identifying an institutional atmosphere or intensifying an institutional atmosphere, other than the fact it's been used in the past, do we need to say de facto social service district?
Yes.
And I know, Michael, you're negative on that one. I know there's a lot of people, and it's interesting that the particular disability of substance use disorder is one that I find the most vocal about words and how words affect, like substance abuse as opposed to substance use, for example, was a hot topic. And so, Dan, I'm actually posing that question to you. I know this is historical, and I want to find out what your thoughts are.
Yeah, the whole origins and concerns going back to 1974 is the creation of a de facto social service district where basically the housing is substantially non-conventional housing, supportive housing, to use a broad term. There's been along the way a number of studies that have looked at this using that term. The reason I think we need this in the legislation is for the legislative history, namely from the study that was done where it's consistently talking about de facto social service districts.
Do you include institutional atmosphere in your study? Was that in there as well?
Not nearly as much.
Not nearly as much, but it was
the sections talking about how to determine whether or not you should allow a home within a spacing distance is talking almost exclusively in terms of de facto social service district. You could just do a search for the terms and you'll see it.
Okay.
I reviewed this, when this was raised a couple of weeks ago, and it's, if we want to have a law that's defensible and capable of being implemented pretty fairly, I think we need to retain the phrase de facto social service district. And to be perfectly honest, I don't think it's going to disturb many people outside of our group. I don't think it casts a negative light on anybody. It's just a de facto situation where you've got it's just doesn't have the feel anymore of a neighborhood.
Okay. Thank you, Dan. Terrell, can you chime in here and give us as a city attorney, give us your thoughts on this term? Because when I look at it, and I don't practice land use law, and I learned pretty much very little on a planning and zoning board for 10 years, at least from what I know now. with regard to these type of issues. It just seems to me that institutional is institutional. But Tara, what are your thoughts?
Between institutional and de facto social service district?
Well, not between, but we have, by creating an institutional atmosphere or by creating or intensifying an institutional atmosphere, do you feel de facto social service district for some legal reason or a fundamental reason in terms of how this statute is going to be applied is necessary?
So I have seen it also in the, DOJ and HUD joint statement. I've seen both terms in there. I've seen it in several, cases and treatises over the years. I think that institutional is obviously institutional. You think of a situation where somebody is in a long-term personal services care type situation. And then as it relates to de facto social service district, that brings to mind a place where you might have multiple, maybe like a medical plaza or a place where it's not necessarily institutionalized care, but it is a situation where you have a group of medical offices together or a group of medical services within an area that, typically is not necessarily going to function like a normal residential situation. I don't know if I'm answering your questions, and I'm sorry I was interrupted a few minutes before you, or just a minute before you asked me by somebody in my office.
You can think more about it, but no, that's very helpful. Recovery. I'm sorry. Community residences have no medical. When I look at de facto social service district, I think of homes like, like, again, medical places, like I think of Medicaid. I think of government run institutions is what comes to my mind. And I'm going to come back to you, Dan. But what I want to know, not as a practical matter, how is it going to affect the operation of this legislation in real terms? Give me an example of where not having de facto social service district, where you do have institutional atmosphere, that is going to change an appellate ruling on a zoning matter. I'm seeing it as enough of a redundancy. And I'm not talking about historically, because historically I get it. I get there's a lot of things historically that have been there's still stuff from 40 years ago in Florida statute that was appropriate at the time. But Dan, I'm going to call on you. I really do I need to know fundamentally how this is going to affect the interpretation of the statute.
Again, the legislative history, the study is a big part of the legislative history, and that is the sections, so chapter 6 or chapter 5 or 7, where we go through, spend about 10 pages on this exact topic. It's all put in the terms of a de facto social service district. And we have the illustrations there showing clustering and concentrations. So that provides the background for this in terms of interpreting the ordinance. This is a terminology that's been used, as you said, historically in the American Bar Association's model zoning, in the American Planning Association's model zoning, in God knows how many legal articles, law review articles, and in studies, not by me, to describe the situation where you've got situation where a very large proportion of the housing is supportive housing. And that creates what a sociologist, and I did start out as a sociologist, would call a de facto social service district. By all practical purposes, the dominant characteristic is social services from supportive housing. If we take it out, it will make it very much harder to defend the ordinance, the statute in court, because the study on which it's based is speaking of de facto social service districts when we're talking about allowing community residents or recovery community within a spacing distance.
Has that come up in court, Dan?
I'm saying, no, it hasn't, because it hasn't been a problem yet.
Right, so that's a speculative argument then.
Yes, it is. And you can
Okay.
please, Jeffrey, I apologize if you were offended before. You read things into what I was saying that I was not saying and never intended to say. Please don't read words into what I say.
Okay. Here's my thought on this. I agree with both of you. It has been in the jargon for 40 years or more as a de facto social service district. I'm also not convinced when you say it'll affect the argument on the viability of the bill. In other words, whether the bill is runs afoul of federal law, I guess. Do you mean like an applicant, or do you mean like a local government that denies something and then it goes to appeal? Is it going to affect their appeal? See, in your study, Dan, and you did it was a phenomenal job of showing examples of clustering, and clustering is clustering. Whether you call it an institutional atmosphere or you call it a de facto social service district, it is what it is. It's a duck. So I'm trying to wrap my head around when coming down, and frankly, I'm going to make a decision on this based on what everybody says, and we could put it back in there if some. I don't know how the bill would be kicked out if we didn't have that specific term, where we do have a term that is synonymous in terms of institutional atmosphere. But anyway, that's my conundrum right now, because I see the merit of what you're saying, Dan. I see the merit of what Jeff and Michael are saying. And if anybody wants to put a postscript on this, I can turn back to Terrell, who's got her hand raised now because she's had a chance to think about it. So go ahead, Terrell.
Thank you, Al. Sorry. Just by way of example, so institutional, whenever I think of institutional, I am thinking of kind of a more intense medical situation where you have intense inpatient care. With a de facto social service district, I have the perfect example very close to my house. And without going into too many specifics, I will simply say that there are a group of duplexes about a block away from my house, in which many of the homes are occupied actually as community residences. And there are regular group meetings at the local playground, all hours of the day and night, weekdays, weekends, where it does tend to, and all different kinds of group meetings, where it does tend to kind of lend itself to more of it starts to look less and feel less like a playground and more like a 12-step meeting space. I'm not saying there's anything wrong with that. I'm just saying that it doesn't necessarily function in the same way that a typical residential pocket park would. And so in that regard, I could see kind of assigning that type of characteristic of a de facto social service district to those duplexes within that vicinity of that playground, because there are so many within such close proximity to each other that it does kind of create more of a situation where at least while they're having meetings there, people aren't necessarily going there with their kids to, play on the swings or ride the slides and that kind of thing.
Okay, thank you. Michael, you have your hand up and there's one on the other hand after you. Michael?
Unless Susan disagrees, I don't necessarily have a problem with de facto social service. I'm a little bit more Machiavellian. Whatever gets us across the goal line, I'm okay with. And as a person in long-term recovery, I don't take insult at that term. I do want to point out and just cross-reference this to FAR standards, and this would sort of relate to FAR's good neighbor policy. I would consider what's going on in Terrell's neighborhood to not be in keeping with our good neighbor policy, and we would have a conversation with that residents or residences to make sure they respect the sort of nature of the community, and not bring 12-step meetings into a child's playground.
Okay, we had another hand up. Did we? No. Okay. Thank you. Any other comments? All right. Moving on to number 2. And let's do in the entire number 2 and have a conversation for 541. Goes all the way through 566. Any, I do have one comment on line 563. I think we have a typo there, where it reads the rules and practices governing the operation of the community residence operates protect the residents. I think operates was in there in error. Shouldn't it read operation of the community residents protect the residents from abuse exploitation? Dan, do you agree? Dan? Oh, he may have.
Okay.
Yeah, 563. I think that's a typo.
Okay, this is the
Well, maybe you mean
standards.
operates to protect the residents. I think we just need to put 2 in there.
Operate to protect. Yeah.
Okay, operates to protect the residents. Okay.
Make it singular.
Operate.
Operate.
Well, that would be operation of the community residents.
The rules and practices, we're talking about, the subject is rules and practices.
Okay, the
So
rules
that's
and
plural.
practices governing the operation of the community residents.
Operate to protect.
Operate to. Yes. Okay, perfect. All right, any other comments on number 2, 541 to 566? Seeing no hands. Moving on to number 3, that would be line 567 through 591. I just have again a syntax question here on 567. Because of A, B, C, and D, I think it should read if a community residence houses more than 12 unrelated people, a reasonable accommodation when the applicant has demonstrated that. Otherwise, it kind of doesn't make sense as a sentence. And correct me if I'm wrong there.
Could you say that again?
So you have a community residence may house more than 12 unrelated people as required in 419-0034, comma, the local government must authorize a reasonable accommodation. I think you meant if a community residence houses more than 12, or there needs to be a period.
Yeah, we could make it when a community residence houses more than 12.
Okay, when a community. Okay.
Take
All
out
right.
A.
Okay, great. Any other comments or questions regarding subsection 3? Okay. Let's go move to subsection 4, which is on page 15, lines 592 through 602. Any questions, comments on that? Yeah, I have another syntax question on 597 through 599. Demonstrates that the proposed transitional community residence complies with section 419.003 and okay, and when applicable. Okay, never mind. That looks okay. Sorry, I misread that.
Hey, I'm amazed you don't have more syntax questions.
Well, you so many hands have gone over this with so many combs. Okay, any other comments to 602? All right, 419.005, recovery communities as a permitted use. All right, and let's look at one was 606, line 606 through 644. I have no comments. Anybody have any comments on that? Okay, similar to except that the distances are increased. Similar to the permitted use in community residences. Okay, let's move on to number 2, the measurement. Now we already have the modifier that if you comply with the code, or if the code doesn't deal with the maximum number of individuals, unrelated individuals, et cetera, that can't be used in any distancing calculation. Even if it's used, if there are 6 people using a recovery residence and there's no cap, that can't be used as a distance for a recovery community as a disqualifier. Okay, for permitted use. Again, this is for permitted use. All right, any questions about number 2, 645 to 652? Okay, let's move on to number 3, 653 to 669.
Got the same issues as before. Okay, Al, you've got the same issues as with the community residences, so whatever you do to that, you should do to this.
Okay. On number 3?
Yeah.
Oh, the 5 calendar day issue. Okay. Yes. Okay. I did have one other question. Okay. Oh, no, actually, no, I don't. Now that we went through the community residence, yeah, I should be able to put that together consistently in here. Okay. Any other questions or thoughts on number 3? Okay, let's move on to line 670 through 673. Shall not affect the legal non-performing. Okay, we're going to move that date again to
January 1, 2027.
January 2027. Okay. Same thing with number 5.
Yep.
Okay. Let's go to 6 and 7, 677 to 687. That's the direct threat language again.
Mm-hmm.
And the local government adopting a new ordinance or adopting less restrictive zoning. Everybody okay? Same thing as recovery, as community residences. Okay, let's go to 419.006. Let's take the entire 419.006 from 690 to 722. We've already discussed de facto social service district. And is there any other issue in 419.006 that anybody wants to bring up?
Okay, I'd like to make sure everyone realizes we've added in here something that I thought cities would have done anyway, but they didn't. In calculating spacing distances in terms of lots, we're counting a street or an alley as a lot, which is only fair.
Right. And that does inure to the benefit of the residences in, you know, in a way. But it is still the 660 distance. You're not going to find, it'll likely be more anyway, not less than 660. But whichever is greater is the one that's used. So, okay, thank you for noting that. I did notice that, and I went, what? And then I realized what you were talking about. Okay, let's move on then to section 419.007. Again, when we look through let's do one first. Okay. That's similar again to community residences only. Well, no, actually, I'm sorry. This is a completely different. The congregate living facilities include medical, don't they? And Dan, if you would let everybody know why it is that that we added this. I remember we didn't have this originally last year, and we added it at the last minute when we submitted it. Why is that?
Yeah, well, if we're going to include congregate living facilities in calculating spacing distances, then we have to define them and regulate them. These are, if you go back to the definition, these are largely living facilities that are not covered by the Fair Housing Act, or they're very institutional in nature, far too large to be a residential use, to be to conceivably emulate a family. There are facilities where treatment is primary more so than residency. So, and this is, you know, I mean, it's a difficult area to deal with. I'm not kidding you. With every city I work with, it's a difficult area, but it's basically as a catch-all for everything that's a supportive living arrangement or treatment arrangement where people also live there, that doesn't constitute a community residence or a recovery community.
Does 419 in its current state deal with congregate living facilities?
No.
Okay.
No.
I'm going to throw this out there because, you know, again, we didn't have much time to discuss this last year. I'm a little uncomfortable bringing a potential medical facility into community residences and community recovery communities, and the fact that we, other than defining what a congregate living facility is, do we really need to deal with spacing distances with congregate living facilities, except where they are within a spacing distance of one of the community residences or recovery communities? I mean, is it necessary to go into depth, or just acknowledge in definition what congregate living is and include them in one of the living facilities that count in terms of spacing distance? Does that make sense?
I think that we certainly want to maintain a spacing distance from community residences and recovery communities. We could take out the spacing between congregate living facilities. But I think that it's probably prudent to maintain a spacing distance, not allow them as of right close to community residences or recovery communities.
Yeah, but can we not do that without describing what their requirements are? They meaning the congregate living facilities. We can include them in spacing distances for what we're really dealing with here, which is community residences and recovery communities, without dictating what. Here's my issue. We bring in a whole new group of entities, persons and entities that deal with congregate living facilities when we dictate what they can and cannot do, or what's permitted and what's, in zoning. Do we really need to have them maybe not be in favor of that part of this, of the legislation? And I'm actually gonna, if Sam's still on the call, and I know he has some things going on, but Sam, if you're still on there, you understand what I'm talking about in terms of the real world in Tallahassee. Is Sam still with us?
He
Um,
left. He had to leave.
okay. Well,
Okay, Al, I see what you mean. I think it's a good idea. My one concern is how do we keep a congregate living facility from locating close to a community residence or recovery community?
well, right now, they're not a permitted use. They're not in the mix. Are they an ADA facility? Because there's medical, I don't know that they are. So if ADA and FHA don't apply to them, I think we're starting to go outside my comfort zone in terms of, I don't want some association of congregate living facilities disagreeing with this and then coming to Tallahassee and blowing up the bill. And Jeff, you've got your hand raised. While you're thinking about it, Dan, I'm going to go and ask Jeff and Terrell. I'm going to ask Terrell as well.
Yeah, I understand what Dan's trying to do and don't disagree with it. I think we have a practical problem of, the history of cities. I'm going to say that as like assisted living and CLFs may have been the oldest litigated type of group home use, ever. And they still are. I think it's the problem we run into is when you have CLFs, especially these days, when they are more, I don't want to say independent living, but they start at like a quasi independent living and probably have everything from skilled nursing down to memory care, as a large type of use or as a continuing care facility. And they might be in quasi commercial districts that could be across the street from a community residence and wouldn't be able to be cited there because there's a community residence within the distance, but in a different zoning district. Or you have a zoning district that would allow for a CLF type of use, and in the limited areas in cities where they're allowed, because they are still very limited and somewhat discriminated against for other reasons. And I think we're making it harder for them to be cited. So to your point, I think that, well, like, at least when Palm Beach County was crafting years ago their Dan's ordinance, and they had like a community meeting, there were a number of people or organizations there that represented assisted living facilities that may have a problem with this, and their lobbyists may have a problem with this and may end up hurting the bill overall because they're not here talking to us today.
Thank you, Jeff. I'm texting Sam as well, because I think Sam's the only lobbyist that's on the call. And I want to get his perspective. But Terrell, you had your hand up as well?
I did not have my hand up, but you did say that you were going to call on me. So I guess I will just try to address it. I agree with what Jeff said as far as, I do think that assisted living facilities and CLFs are some of the oldest group homes, if you will, in the state of Florida. I think that the way this is drafted, I agree that it might be difficult to cite the CLFs, because if we're providing for recovery communities, in some ways, some of these CLFs do function in a similar manner as far as the amount of people. And as Jeff pointed out, sometimes it's somewhat independent living. And so I really am kind of on the fence with this. I'm okay if we leave it in, and I'm okay if it comes out. I really am just interested to see what those who are in the CLF industry have to say about it.
And doesn't ACA, before I call back on Dan, doesn't ACA
Yes.
license?
Yes.
So then ACA now becomes a player where we did not put Department of Health or ACA in.
Yeah.
Okay,
ACA licenses everything else except recovery residences, if you know what I mean, or overseas. Any other kind of well, there's also the Agency for Persons with Disabilities, APD, that kind of falls under DCF a little bit, but also ACA. It's like a joint ACA DCF partnership.
And ACA was in the original 419, so we haven't necessarily changed that.
Okay. All right. Well,
But all of these uses under CLFs are going to be an ACA regulated or licensed or cross-licensed facility.
Okay, I think I have a solution.
Go ahead, Dan.
Okay, first, keep in mind the small assisted living facilities are community residences. Keep that in mind. The ones that are small enough to emulate a family. Otherwise, we could just take out section 7 and 8, remain silent on this, and let the local zoning determine how they want to handle it.
I would be in favor of that because I always thought that putting that in there it's kind of like, putting an apple in with an orange. And once you do that and people start furrowing their brow, and then you bring a whole new constituency in to say, what's this then? Unless somebody really has a Jones to keep it in, and thank you for that. I think we should just take it out now. If it needs to come back in at some point, we'll do it. Anybody have any more thoughts on that?
Good idea.
Okay, so what do we have left? Man, look at us, it's 3:30. Dang, 2.5 hours. I'm proud of y'all. So congregate living would take out 7 as well. And then we only have left section 8. Oh, okay. All right, let's talk about section 8 and whether we need that in there or not, now that we're taking congregate living out.
Oh, we need it.
Okay.
This
Let's
is
talk.
intended to make sure that cities give to one under for
This is a procedural
49
statute.
Yeah, it's responsive to many of the concerns Jeffrey's raised. This requires the city to, within 10 business days, to tell the housing provider whether or not it's a permitted use, or if it's within a spacing distance, then it's going to require them to provide to the applicant, if they want, all the information they need to show that they meet the standards to be allowed within the spacing distance.
Okay, so
without charge.
Okay, so if I'm getting this right, as long as we define what a congregate living facility is in the definition section, we can put section 8 in because it's a qualifier in the larger scale to the spacing distances regarding all community residences and all recovery communities. Is that a fair statement?
Yeah. And we can take out.
I mean, I would take out congregate living facility because it's confusing now.
Okay,
take out congregate living facilities from this section.
Yeah.
So should it be community residence, recovery communities, applicable spacing distance?
Yes.
Distance? Okay.
Yeah, and I'll work the language for you and get it to you.
It's got to be like immediate, because I'm going to be sending out something to everybody to look at, because I've got to get in a draft that is usable for the committee staff.
Yeah, I'll get it to you
That
today.
means like probably by Thursday. So I have to make the changes, send it out to everybody, which I'm happy to do. If I get it in by Friday, that nobody's going to die, we'll all live. But Senator Harrell is the most pleasant person you're ever going to meet. And she did not yell at me, but she was concerned that if we get behind a bunch of other legislation and they don't get to us for a couple of months, it's not going to be out in time to fix. Because anything the staff does that's as important and extensive as this is going to have changes that we're going to have to deal with. So that just says, just get it to me as quick as you can, and I'll get it out to everybody along with the changes we've discussed. I'm going to tell you right now, I'm keeping in de facto social service district for right now. I want to think about it some more. I may take it out. I'm back and forth on it. what Michael said was very important to me. Because it's not about feelings. Although it is about feelings, but it's not. It's about getting it across the line. It's about making sure that that we have a broad base of support. So let me think about that. It may be in it, maybe not. It'll be a shocker. Do the under and over. I don't know what I'm going to do. Hell, anything else regarding this? We're at the end, 21 to 21. Anybody have any other comments for the rest of the section 009? And section 10 is just, boilerplate that's in the existing language.
Al, I just want to thank all of you. I think you've done a wonderful job, and this is great.
Well, I want to thank all of you, especially Jeff and Dan, Carol, yourself, Susan. This could not have been done without people independently working on this. And I think we got a great mousetrap here. So now we need to get support. I've got several lobbying groups that deal with ADA housing. I think we can get a broad-based support from all the different disability groups, which would be really important. I'm going to get this. The other reason I want to get this done is I need to get this out to the League of Cities and the Association of Counties presidents. Last year they were on board with this, but that was, Jeff, I'm sorry, that was Sam and Lauren Jackson. And, I want to make sure we get a League of Cities, and if we get League of Cities and Association of Counties support, or at least tacit support on this, I think we have a very good chance. And some of the people in the treatment industry, if I can get the entire treatment industry, and I know, Michael, you and Jeff know what I'm talking about, because there are those in the industry that think there should be no, little or no, especially in multifamily districts, a bunch of people that feel that there should be no restriction. And me, I'm a half a loaf guy, so I think this is 3/4 to 80% of a loaf. I think we can live on this. Any comments? This has been a crazy good session. Thank you for all your ideas and for listening. Anybody have any comments for the good and welfare before we, now, we're having a meeting. We're having 2 meetings in September. We're going back to 2016 and 17 where we did this like too many times. But as Jeff said, the fire is 90% contained. And so that's why we have bi-monthly meetings. We're having a meeting on September 10th, 1:30 to talk about the legislation again, to see if there's any changes. That may be a very short meeting. I also would invite on the 10th, I know that FAR is considering legislation. And if you can have that together, we can add that and talk about it on the 10th as well. I mean, different issues, and that's welcome. And then on the 17th, we're going to have a rollout of DCF's new website, and they're going to do a demonstration. I think I'm hoping that everybody be very pleased about that. We'll also have the healthcare district give us an update in September 17th. That's a regular meeting. The 10th is going to be a legislative meeting again. We do have a working group that I announced at the beginning, and I'll be sending it out to everybody though, for everybody's input. I want to hear what everybody has to say. And I'd like to thank Maureen Killian for her chat input. Maureen, it's always good to hear your thoughts because you got boots on the ground, like Ariana, like Jeff, in their own spheres. Okay, thank you, Dan. Really, thank you for getting this done.
Hey, Al, I don't want last word. I want you to have last word, but I do want to remind you and everyone, and Dan, put it in the ordinance, or the statute, I appreciate it. But we really need to soon wrap our heads and hands around mental health housing. It's like it's the clear elephant in the room that's exploding everywhere, and we're doing our best to manage it and contain it and control it. But it's kind of like AI. If we don't get ahead of it, then we're going to be responsive to it.
Okay, I just got a call today. Well, actually, healthcare district is hitting this head on. And that's probably going to be part of their presentation on the 17th.
Okay.
Michael, you've been dealing with this with FAR certification. From that end, can you put something together for our discussion on the 17th? Because we have room. We're not talking legislation on the 17th. We'll be talking, issues affecting Palm Beach County and the state.
The answer is yes. I think he's off.
Okay. All right. Great. We'll be doing updates on the 17th, from Oxford House, from FAR, the numbers from the medical examiner and fire rescue, like usual. I don't need the last word. Who wants to give the last word? Doesn't have to be me. I talk too much. Come on, Terrell, you be the last word.
Thank you all. I know everybody worked really hard on this, and I think it was a great meeting. Thank you so much.
All right. Couldn't have said it better in 1,000 words. All right, y'all take care. You'll get some stuff and by email, and we'll see you on the 10th, September 10th. Yeah, we were down to 9 people at the end. I knew that would happen.